Mr. Brown, you're here for sentencing on violating your probation. You were on probation to this court for a misdemeanor, a 1-year misdemeanor of malicious destruction of property. Mr. Gilbert, have you had a chance to review the probation violation report with Mr. Brown?
We did, Your Honor.
Do you have any additions or corrections to the information in that report?
The only thing that my client wished me to point out was in the evaluation and plan, the second paragraph, there's a sentence that says that he has since moved in with a convicted felon. He just wants you to know that the probation officer knew that. That was not something that he did without fully disclosing that to the probation officer.
Okay, and that, I mean, he's not, that wasn't, doesn't constitute a violation for which he's here then. Okay. All right, Mr. Radzaban, any additions or corrections to the report?
No additions or corrections to the factual content, Judge.
All right, and this was a misdemeanor for which Mr. Brown was on probation primarily for restitution, which he's paid. So there are no guidelines range. Mr. Gilbert, anything you'd like to say on behalf of Mr. Brown?
Well, the court identified pretty much my main argument for the sentencing or allocution is that the primary purpose of his probation was to pay back the substantial sum of what that first case was about, which he has done, and made the victim in that case whole by the replacement of the trailer. There was a tow trailer that he completely has taken care of the restitution. Furthermore, he hasn't been sentenced in Sheboygan County on the underlying offense yet. Yeah, we did go through sentencing. I apologize, Your Honor, and there was no jail time associated with that. I do believe that has to do with the new guidelines. And we'd ask that the court, follow basically that if and not give him any jail time if he doesn't get it on the major offense. The court to take that in consideration, and I see where they want him off probation, but he has accomplished the main goal there, and consider no additional jail. Thank you.
Okay, thank you. Mr. Brown, it's not required that you would make a statement, but it is allowed. Is there anything that you wish to say?
Well, I know I messed up in life, and just want to get through this and continue on in life without using alcohol and making good decisions.
Okay, thank you, Mr. Brown. Mr. Radzaban, recommendations from the people?
Your Honor, we believe a short period of incarceration would be appropriate. I'm asking that you impose 14 days jail credit for 2 days service.
All right. Well, Mr. Brown, you've made a fairly simple matter much more complicated for us here. Looks like back last summer, you were in here for sentencing on a charge of destruction of property, punishable by up to a year in jail. And it had involved, I think it involved alcohol. It was an argument at a bar, and I think the alcohol was involved with that. And we put you on probation, which I don't tend to do for misdemeanors, primarily so that you could pay the substantial restitution, which was over $4,000. There was a plea agreement for a 3-month jail cap. The recommendation of the probation department at that time was that you go to jail for 2 months, for 60 days, with credit for 2 days that you served before. Back at that sentencing, I did not follow those recommendations, and I gave you no jail. I held it in abeyance, right?
That's right.
And then we were back here for a violation of probation. And you had paid your fines and costs, but the alcohol had resumed, it had reared its head. And, you were intoxicated, had consumed alcohol. Police had to be called to an apartment where you weren't wanted. And at that time, the probation department pretty understandably recommended, hey, you remember those 58 days that you held over his head? Now would be a good time to use them. How many of those days did I give you?
None.
None. That's right. I extended your probation, gave you some community service, gave you a chance to continue your substance abuse treatment. And now you violated probation again by committing a crime. It's not a technical violation. You drove while you were impaired. And the probation department, perhaps, being twice gun shy, hasn't recommended a particular number of days to give because I haven't listened to probation to date. But I'm going to listen to him today, Mr. Brown. I don't, you would not have had to go to jail on this case, but you've really forced our hand to do that. I hold 58 days over your head a year ago when they were recommended. You violate, and I don't give you those days. Perhaps that's my fault. Perhaps I should have given you a little bit of jail then, and Mr. Bloomley's probably nodding his head over there. But I held him over your head again, and now we have a second violation. It's worse than the first one. It's a new crime. You're going to do the 58 days. I'm sorry. So I'm going to revoke your probation, Mr. Brown. I'm going to sentence you to the Presque Isle County Jail for 60 days and give you credit for 2 days previously served.
Your Honor, if the Presque Isle County Jail starts having, I don't know if they have yet or not, work release, would the court consider that?
Where's he working?
I work for EH, I guess he's logging.
Mr. Radsbaum?
So we're
Zagetsky's logging.
Revokes logging. Means he's driving a truck all over the place.
I'm on the skidder,
He's on the skidder.
Oh, at that site,
yes.
I would not oppose that.
Okay, work release for standard work week hours will be authorized.
Thank you very much, Your Honor.
All right, Mr. Brown, good luck.
Thank
Let's see who this is. We have Mr. Mason present in the courtroom with his attorney, Mr. Vogler. Prosecuting attorney, Mr. Radsbaum, present as well. We're providing public access both in the courtroom and online. And Mr. Mason, looks like we're scheduled for a docket call on September 13th at 9:30 in the morning. But you're here today on a show cause. The prosecutor is alleging that you're in criminal contempt of court for violating the conditions of your bond by missing several drug tests on May 26th, May 28th, May 29th, May 30th, June 2nd, and June 6th. You have the right to have a hearing on that issue. And where it would need to be proven beyond a reasonable doubt that you are in contempt of court, you have the right to have Mr. Vogler assist you at that hearing. If you are found to be in contempt, I could sentence you to up to 93 days in jail or revoke your bond. I could give you a $7,500 fine as well. Do you understand the rights that you have and the penalties that you can face, Mr. Mason?
Yes.
All right, Mr. Vogler, do you know how Mr. Mason wishes to proceed?
Yes, Your Honor. He'd like to have a hearing, but really to prepare for that hearing, I was informed by Mr. Mason last week that there are other records existing that we need to subpoena with regard to some of these test results in particular. Mr. Mason saying that, for example, on 6/6/7 a.m., a missed test, that he actually tested early, but they're not reporting that on the document.
Well, maybe he's confusing that. This is a, look at the June 6th. Are these misses on the sober link, Mr. Radsbaum, or?
Yeah. Yes.
Oh, okay. Okay. All right, well, we'll schedule this then for a contempt hearing. Mr. Radsabon, any objection to setting it for the same time as the docket call?
On August 2nd.
Right, it was scheduled for September 13th.
Oh, yeah, that's fine.
Okay.
Judge, just for the record, since we had prepared this show cause, there's also one more test that came in on July 7th, which showed at 3:01 PM a blood alcohol content of 0.098. So we would add that potential allegations as well. We test 6 more times, 360, 546 that day.
All right, so those allegations will be added then to the show cause for that hearing, Mr. Vogler. July 7th. Positive sober link. All right, and so we'll schedule that for a hearing on the September 13th, same date as the docket call. Mr. Mason, what I want to tell you is, I mean, you're on bond on some very serious charges. If I were you, I would want to make sure I stay out on bond. That means I wouldn't drink a drop, and I would blow every time I'm supposed to exactly in those windows. That's what I would do if I were you. And Mr. Radsabon, now with an alleged positive too, I guess I'm going to say you have the right to have a hearing, but we also have lots of issues going on. If there's another positive, I would sign a warrant for your arrest if the prosecutor submitted it, and we would have the hearing that way. Okay. So I don't want you to tell me anything right now about this existing violation, but if you were drinking, no more. If you drink on this bond from this day forward, you're going to sit in jail until your trial. Right? You understand that?
Yes, sir.
All right, we'll see you on September 13th then in person.